Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. This month we start with two more cases that emphasise that the courts are rarely willing to imply words or override written words in business-to-business contracts. The first case, Good Life Foods v Hall Fire Protection, concerned Good Life's purchase of the fire protection system, which it claimed failed and caused $6 million plus of losses. The Court of Appeal, agreeing with an earlier decision in May last year, held that Hall Fire was not liable. It had clearly included a wide exclusion of liability clause in its contract and had even offered insurance as an extra cost item, an option Good Life had chosen not to buy. Our second case, Boyes Simon v BGC Brokers. BGC made a payment to Boyes Simon to join the business. Boyes Simon joined the business but left shortly after. BGC then asked for the payment to be returned, claiming it was implied term that it would be returned if he left in the initial period. The Court of Appeal, agreeing with Boyes Simon, held the payment did not need to be refunded, as this was not required by the contract. The terms were clear, so there was no reason for the court to imply any terms into the agreement. It was also helpful to Boyes Simon's case that he could show an early draft of the agreement had included a requirement for repayment, but this had been deleted. In recent months, we have reported on good faith clauses and that they will rarely be implied into commercial contract. But what's the important when an obligation to use good faith is expressly stated in a contract? The recent case of Health and Case Management HCM, the Physiotherapy Network PN, is a good example of how it can rescue a party when all else fails. The parties agreed a referral contract for HCM to refer patients to PN, but unbeknown to PN, HCM started to establish its own physiotherapy network using information supplied by PN. When this became known to PN, it sued for not providing sufficient referrals, for breach of confidentiality and for breach of an express good faith provision. The court held that whilst the other claims failed for various reasons, HCM had not acted in good faith and was therefore in breach. The court provided guidance on what good faith means: acting honestly, adhering to the spirit of an agreement, observing reasonable commercial standards of fair dealing, being faithful to a common purpose, and acting consistently with the parties' justified expectations. In 2007, following the Kenyan presidential election, there was an upsurge in serious violence. Following this, some employees and residents living on a large tea plantation run by Unilever's subsidiary in Kenya claimed that Unilever owed them a duty of care. The Court of Appeal disagreed and said that the claimants were nowhere near to showing that Unilever owed the claimants a duty of care. To establish a duty of care by the parent company, it would need to have taken over the management of the subsidiary and/or required compliance with its relevant advice. Now, whilst this decision is helpful to parent companies, it lacks guidance on when a parent may step over the line of requiring compliance with its advice and therefore become liable for the acts of its subsidiary. The FRC has published the final form of its new UK Corporate Governance Code. It applies to all companies with a premium listing of equity shares for reporting years starting on or after the 1st of January 2019, so coincides with the new statutory requirements that we reported on last month. The code includes engagement with the workforce, chair and board independence, diversity and remuneration. To demonstrate engagement with the workforce, the code recommends either a director appointed from the workforce, a formal workforce advisory panel, or a designated non-executive director. There are new calls by the European Parliament to invalidate the EU-US Privacy Shield. The Privacy Shield permits personal data to be passed to US registered companies, but has been criticised for not being compliant with the new General Data Protection Regulation. The European Parliament has asked that it is made fully compliant by the 1st of September of this year. A recent Court of Appeal decision reversing previous decisions, decided that workers carrying out sleep-in shifts do not have to be paid in full for the purpose of the National Minimum Wage Regulations, the NMW. This decision is, however, fact-specific. This case involved a care worker that was not expected to carry out any duties at night unless she needed to assist her vulnerable adult. Evidence showed that she had only been needed to assist on 6 occasions in the previous 16 months. The court therefore stated that in this case the worker was merely needed to be available for work as defined in the NMW regulations. Where the worker is required to do some work in the night, then the decision is likely to be different. It's understood that Unison is planning to appeal the decision. For a whistleblower to have the protection of whistleblowing laws, the Court of Appeal has decided that there must be disclosure of information with sufficient factual content to show a relevant failure, such as a breach of a legal obligation. A mere allegation will not be sufficient. Employing a person that is not lawfully entitled to work in the UK exposes employers to fines of £20,000 per employee. In a recent case concerning an employee whose visa was expiring on the 12th of August of 2016, the employer sent repeated reminders to him to provide evidence that he may lawfully work beyond this date. Now, he eventually sent an email with evidence on the deadline day, but the employer was unable to open the attachment, so dismissed him without a right to appeal. The Employment Appeal Tribunal, the EAT, decided that although the dismissal could be justified, an appeal would have allowed the matter to have been dealt with calmly and the dismissal rescinded. This case will now go back to the tribunal to consider issues such as contributory fault. We've reported in previous months on a long line of cases that have looked at the dividing line between worker status and an independent contractor. This month we consider a case that looks at the dividing line between worker status and employee status. Perhaps the most important factor in defining an employment status is whether there is mutuality of obligations. In Hafal v Lane Angel, LA was engaged on a bank basis. She had no guaranteed hours and was only required to work if she was available. There was, however, a 3-strike rule whereby she would be removed from the list if she missed 3 call-outs on an agreed rota. Now, following some failures to respond to a call, she was removed from the list and she brought an unfair dismissal claim, which required her to first prove she was an employee. The EAT held she was not an employee as there was no mutuality of obligations. There was an expectation that she would work, but that was not the same as an obligation to do so. The Competition and Markets Authority, the CMA, has published guidance for consumer law in the online dating sector. The guidance is, however, useful for other sectors too. It focuses on clarity and ensuring consumers understand how their data will be managed, letting customers know before their subscription is about to renew and payment taken, ensuring customers have been told of their statutory rights, providing sufficient notice and opportunities to cancel if the business changes its terms. The CMA has also announced that it is taking enforcement action against hotel booking sites. The CMA has identified concerns including the ranking of hotels in search results, pressure selling tactics such as the creation of false impressions of room availability, the fairness of discount claims and hidden charges. Thank you for tuning in for this month's Commercial Bulletin. For more information on any of these stories, please contact me or any of my colleagues at Radius Law. We're taking a short summer break, so there'll be no vlog for September, but we'll be back in October.